Hi, Attorney Rick Wimblott here, talking today about special needs trusts. I'm an attorney here in Edmond, Oklahoma, but more about me later. Who could benefit from a special needs trust? Well, certainly anybody with a developmental issue, but also those with alcohol or substance abuse or mental issues. It can also include someone who's been injured or disabled because of an accident or perhaps service in the military. It can also be beneficial for those who perhaps suffered a stroke, suffering from dementia, or Alzheimer's. Special needs trusts are a way to provide for the necessities of individuals such as goods, services, education, vacations, hobbies, sports, pets, housing, clothing, entertainment, transportation, and other luxuries. What we're looking at doing with the Special Needs Trust is to provide a way for the finances to be there to enhance the individual's lives. We probably need to back up a second and talk about what a trust is after all. First of all, there's three parties: the grantor, trustee, and the beneficiary. The grantor is the person who sets up the trust and provides the financing for it. The trustee is the individual that is responsible for everything, and the beneficiary is the person who benefits from the trust. When the trust is set up, the trustee gets legal title to the property or money that belonged to the grantor, but the beneficiary has the beneficial interest in the property, and the trustee is supposed to use the property only for the benefit of the beneficiary. How is a special needs trust different from a regular trust? The goal of a special needs trust is to enhance the person's life, but we also need to make sure we protect needs-based benefit eligibility, protect assets from losses, and also to develop a plan for advocacy. Needs-based benefits may include Social Security disability income, Medicaid benefits, housing such as Section 8, and SNAP or food stamp benefits. What does needs-based mean? Well, certain governmental benefits require that a person have limited resources. There may be an income test. If the person has too much in income, they may not be eligible. There's also an asset test. Usually, if a person has more than $2,000, they become disqualified. The biggest benefits we have are Social Security and Medicaid. When an inheritance is received, these benefits can go away. When I'm talking about inheritance, I'm not just talking about what's left in a will. Other things such as life insurance death benefits, amounts left in an IRA or a retirement fund, bank accounts naming an individual as a beneficiary, these all can cause disqualification. How can a special needs trust maintain means-tested eligibility? Well, the trick really is in who holds title to the property. As we recall, the trustee is the owner of the property, or at least the legal owner. So the beneficiary doesn't have direct access to the income, and the property is not titled in his or her name. The next issue of concern is to protect the assets from loss. If money is given directly to the beneficiary, they can be lost in a variety of ways. For instance, a divorcing spouse may claim the money. It could also be lost in a bankruptcy proceeding. If the money is not protected in a trust, it could be subject to judgments or poor money management skills of the beneficiary. We also want to protect the individual from those who would prey upon them, either by borrowing money, convincing them to make bad investments, selling them drugs, or other bad acts. That's why a trustee is so important, because a trustee can stand in the way of these dangerous predators and creditors and protect the funds and the money for the benefit of the disabled individual. A third goal is to develop a plan for advocacy. we can require the trustee consult with the beneficiary, guardian, the representative, or perhaps a committee of family members to determine what the beneficiary's needs are at that time. A trust protector is another individual who can serve as a go-between between the beneficiary and the trustee to work out any issues and maybe find solutions. The trust should also have a mechanism so that if there's a trustee who's not performing or is just a bad trustee, they can be removed and replaced with another trustee. The most common type of special needs trust is called a third-party trust. This is a trust that is set up by someone other than the disabled person, such as a parent, grandparent, relative. It really can be anybody. A third-party trust is created using money that doesn't belong to the beneficiary. A third-party special needs trust is revocable, which means the grantor can make changes to it. It can also be set up so that others can contribute to it, either by will or by gift. The trust also controls the funds even after the beneficiary dies. This means that any leftover money can be given to another family member, a charity, whoever the grantor chooses. Finally, there is no requirement that the trust be used to pay back anything to the state for any benefits or medical services received. Funding sources for the third-party trust can come from a variety of sources, including life insurance benefits, IRA or 401ks, properties such as homes, businesses, farms, cash, but most people will have it as part of their inheritance that they're leaving the special needs person. There are also very limited ways that a person can set up their own special needs trust. These are fairly rare. The person is using their own money and is typically from a source such as a settlement, lawsuit, or inheritance. There are federal statutes and special rules that apply that really are beyond the scope of this presentation. But just be aware that if someone is possibly going to receive a settlement and the person is on or is about to be on Social Security disability income or on Medicaid, it's worth looking into before accepting a settlement from a lawsuit or from an inheritance. One of the things I hope you come away with is that standard planning is usually the wrong approach whenever there's a special needs in the picture. Thanks for listening. Again, I'm Richard Winblad, attorney here in Edmond, Oklahoma. There's a picture of my office, and here's my contact information. If you have questions, comments, or would like a consultation, I can be reached at 405-340-6554. Keep in mind that this presentation is for informational purposes only. This is not a comprehensive discussion of the topic presented. You may have different needs, and there may be different avenues you might want to pursue. These materials do not and are not intended to be used as legal advice. They don't create an attorney-client. Listening to these materials does not create an attorney-client relationship. Please seek the advice and assistance of a knowledgeable attorney before making any such decisions. I'm licensed in Oklahoma and only practice here.